Um, First of all, I want to thank all of our panelists for sharing their insights with the committee today. Each panelist will have 5 minutes to make opening remarks, and we'll reserve the rest of our time for Q&A and conversation with the committee. Panelists, please know that if you've given us a written submission, we have read it. So in your opening remarks, please move quickly to the high points so we can move on to the conversation, which is really the most important and productive part of our meeting. This panel is going to give us an overview on more data relating to bail and pretrial release. I'm going to apologize in advance if I mispronounce anybody's name. But our panelists are Stephanie Campos-Bui, is that correct? Great. Assistant Clinical Professor at the Policy Advocacy Clinic at Berkeley Law School. Irene Vignanti, is that correct? Is that correct?
Yes, it is.
All right, thank you for joining us. From the Los Angeles County Office of the CIO, and Kate Weisberg, Associate Professor of Law at George Washington Law School. Good to see you, Kate. Good to see you, everyone. We'll hear from each of the panels for 5 minutes and then Q&A. Professor Campos-Bui, we'll start with you.
Great. Thank you, Chair Romano and members and staff of the committee for including me in the discussion today. Today, I'm here to share some findings from a forthcoming report analyzing the implementation of the 2021 California Supreme Court decision in Ray Humphrey. Over the last year, my co-authors and I have embarked on a review of various quantitative and qualitative data sets to better understand the impact of the decision. We analyze publicly available information, including data on the jail population held by the Board of State and Community Corrections. We have sent Public Record Act requests to every court, sheriff department, district attorney's office, and probation department in all 58 counties. And we've also circulated a survey to defense attorneys and prosecutors across the state. And before I jump into kind of an overview of the main findings of the report, I do want to note that the ability to isolate the direct impact of the Humphrey decision was limited by various factors, including lack of relevant data on pretrial release decisions, the simultaneous operation of ongoing pretrial pilot programs, and COVID-19, which prompted, as many of you know, courts to adopt emergency zero bail policies. Nevertheless, we think it's important to share kind of what we've learned. First, as Dean Chemerinsky kind of previewed, there's no evidence that Humphrey has resulted in a net decrease of the pretrial jail population in California. In fact, available BSCC data on the sentenced and unsentenced jail population, although an imperfect data source, suggests that there is an actual overall increase in the percentage of the unsentenced jail population post-March 2021. So in other words, there are actually more people in jail awaiting trial after the Humphrey decision as compared to before. Second, there's also no evidence that Humphrey has resulted in a decrease in bail amounts across the state. Based on relevant data from about a dozen counties, we found that bail amounts continue to range widely post-Humphrey. For example, in San Mateo County, the median bail amount dropped to $250 for most misdemeanors and felonies due to an emergency bail order that the court adopted in 2021. But that quickly has jumped back up in 2022 to $7,500, which is kind of pre-Humphrey rates. Despite the fluctuations in bail amounts in San Mateo, the percentage of people who are able to bail out has stayed consistent, though, over time at roughly over 25%. In contrast, we look at Merced County, for example, where median bail amounts for both misdemeanors and felonies have roughly stayed the same, but 2.8% of all people ordered to pay bail are actually able to bail out, which suggests that bail continues to be set at unaffordable amounts. Third, there's no evidence that Humphrey has resulted in a decrease in the average length of pretrial detention in California. So while the explicit goal of Humphrey was not to change the average length of pretrial detention statewide, in San Francisco County, for example, the median length of stay following the 2018 Humphrey ruling decreased length of stay by about a week. Looking again at the BSCC data, we see that 40% of counties actually saw an increase in average pretrial length of stay post-Humphrey as compared to before. Through our research, we also found kind of significant changes in the ways in which certain stakeholders are approaching pretrial decision-making and outcomes. So for example, we've seen many judges interpreting Humphrey as having increased their authority to order no bail holds. We've also seen multiple probation departments create or expand kind of their pretrial service programs as a direct result of the Humphrey decision. So based on our research, our report recommends a number of kind of structural and systemic changes, mainly targeted at the Judicial Council and the legislature, which include adopting and enforcing a statewide uniform $0 bail schedule, codifying a presumption of release in all cases, funding indigent defense at earlier stages of a case, funding jurisdictions to establish pretrial service agencies, ideally outside of law enforcement departments, and finally requiring the collection of data on pretrial release decisions and outcomes. As you know, it's been over a year since the Humphrey decision came down, and the changes in practices that I think we all had hoped for and anticipated have simply not occurred. Humphrey on its own was just not enough to change, I think, approaches to pretrial detention. And so moving forward, there needs to be a multi-pronged approach to really address this issue. And otherwise, I think the promise of pretrial justice will continue to be unrealized in California. Thank you for your time, and I'm happy to answer any questions after the other panelists present. Thank you.
Thank you very much. Ms. Vinyati?
Thank you. I am Irene Fidiente with the Office of the Chief Information Officer in LA County, and I'm here on behalf of the Pretrial Data Initiative in LA County, which is an initiative that I lead. So the objective of this pretrial data initiative in the county is to inform pretrial efforts in LA County, but we do have a specific focus on understanding how reforms that have been enacted and or accelerated by the pandemic impacted our pretrial system. And we know that as Dr. Campos-Boy has just mentioned earlier, there are a lot of reforms that have been enacted during the pandemic, and obviously the pandemic itself also accelerated a lot of changes. And $0 bail, I think, is one of the prominent ones. And secondly, we also focus on studying who was released from jail, why they were released, what made them successful, as well as how the trajectories of releases change over the course of the pandemic compared to what they were in the pre-pandemic era. So to that end, we link several administrative data sets. We link booking data from the many law enforcement agencies in LA County to LA Superior Court data to enable us to trace the trajectory of LA County pretrial population from the point of arrest to the conclusion of the pretrial period, and also to learn how this trajectory changes over time. So today I'd like to highlight some findings from the latest quarterly update, which is focused on understanding how the pandemic, as well as reforms and policy changes that were enacted during the pandemic, have changed the pretrial landscape, so we can be very responsive to how these changes have happened in our efforts in pretrial reform. We examined 3 time periods. 1 year pre-pandemic to establish what the trends were pre-pandemic, and also we look at years 1 and 2 after the onset of the pandemic, so we can understand how the onset of the pandemic changed the pretrial landscape and whether the changes persisted 2 years into the pandemic. So to summarize the findings, we find that there are lots of changes, and it makes it kind of complicated to really pinpoint how one of the many reforms that have been enacted during the pandemic really changed things. But we find that there is a very significant change upstream in the pretrial landscape. We saw that the volume of arrests after the onset of the pandemic halving of what they were pre-pandemic, mostly affecting misdemeanor arrest. And this reduction in arrests has persisted 2 years into the pandemic with much lower rates of arrests 2 years into the pandemic. So this has consequences downstream, obviously, as the number of court cases also dropped significantly after the pandemic onset. And this, again, mostly affects misdemeanor cases. We also saw that the beginning of the pandemic bringing on higher rates of own recognizance releases and cite-and releases, but the post-pandemic trajectories differ for misdemeanor and felony cases. For misdemeanors, the rates of release for own recognizance and cites went back to their pre-pandemic rates after a spike in the beginning of the pandemic. But for felonies, 2 years into the pandemic, we saw that the rates of release for OR and cite are significantly higher than their pre-pandemic rates. We also looked at how pretrial outcomes trajectory changed during the pandemic. We specifically looked at failure to appear as well as rearrests for new offense rates. And because we wanted to see how this changed throughout the pandemic, we were looking at monthly rates. We saw that there was a spike in failure to appear and rearrest rates early on after the onset of the pandemic, and this is particularly severe for felony cases. But 2 years into the pandemic, we saw that those rates have stabilized to levels similar to what they were pre-pandemic levels. We also look at cumulative FDA and rearrest rates. And I should note that these are different from monthly rates because cumulative rates are estimated over the entire life of release cases. And 1 year pre-pandemic, looking at that cumulative rate for that cohort, the FDA rate was 46%, and 1 year post-pandemic, it is also 46%. 2 years for those who started in year 2 after the pandemic is 42%. And for rearrest for new offense rates, we saw that the rates are accordingly 35%, 40%, and 32% for these 3 cohorts. So this is an ongoing project, and I will be happy to come back to the committee to present new findings in the future. For our next update, we plan to look at how the pretrial population composition in LA County changes for the 3 cohorts, how the pretrial outcomes change, the release composition, how the release composition also changed, looking at cumulative rates. And we also plan to look at breakdowns of rearrest rates in terms of what % of rearrests are for misdemeanor or felonies, as well as the breakdown in terms of charge categories, whether it's violent or non-violent, property versus drug crimes, and so on. Thank you very much, and I'm looking forward to the questions after the next panelist presentation.
Thank you very much. Professor Weisberg.
Great, thank you so much.
Good
It's great to be with you all today. Thank you for inviting me to speak with you. I'm a law professor at George Washington University School of Law. And previously, I was an attorney at the East Bay Community Law Center in Berkeley, California, where I defended young people in juvenile court, many of whom were ordered to wear electronic ankle monitors. So in the next few minutes, in my 5 minutes, I'll explain what we know and what we don't know about pretrial electronic monitoring and offer some recommendations. The main takeaway from my comments is that the current use of electronic monitoring pretrial undermines the goals of bail reform, such as addressing racial and economic inequity and identifying more effective alternatives to pretrial detention. So what do we know about electronic monitoring? Throughout the country, including in California, the use of pretrial electronic monitoring is rapidly expanding. At the same time, pretrial detention rates, as we've heard, are not going down, suggesting that monitoring is having a negligible effect on reducing pretrial detention. The expanded use of pretrial monitoring is hardly surprising. It's generally viewed favorably. In fact, the Humphrey decision itself mentions pretrial monitoring at 5 different points in the decision. But while it's not as oppressive as a jail cell, the operation of electronic monitoring, like jail, restricts liberty, limits privacy, disrupts family relationships, and jeopardizes financial security. So in my research, I analyze how monitoring operates. And let me just share a few themes, and there's more detail in my written submission. So people are usually subject to dozens of complicated and invasive rules. San Francisco, it's 22 rules. San Diego, it's 26 rules, and those are pretty average. These rules are very detailed. They're one size fits all and do not accommodate differences in age, gender, mental or physical health, or housing status, differences that generally impact how well someone can succeed on electronic monitoring. People on monitors are almost always required to remain in their home and cannot leave unless they obtain pre-approval, a process that is often very complicated. For example, in most places, going to a job interview or driving your children to school requires pre-approval. People on monitors have virtually no privacy. The data collected through ankle monitors are highly sensitive, historic location data. The data is routinely shared with law enforcement. And in many places, these devices have audio features that have microphones and allow the agents to speak to people who are on the monitors, or the monitors have beeping features that alert everyone in earshot of the person on the monitor. There are also significant burdens on families. For example, family members must agree to all the rules, must maintain electricity, pay for a landline or a cell phone, not allow new people to join the household without permission, and subject themselves to warrantless searches at any time. These rules are most often agency generated and subject to very little court oversight. And of course, the violation of any of these rules can land people back in jail. So in short, the harms of electronic monitoring, echo the harms of pretrial detention, even if to a lesser degree. People may feel pressure to plead guilty, the rules are unnecessarily restrictive and invasive, and the risk of reincarceration for technical violations is quite high. So what don't we know about electronic monitoring? While I've described some of the harms, there's limited evidence about the benefits of monitoring. First, and I think this is really important, there's virtually no evidence that monitoring furthers public safety or improves court appearance rates as compared to less restrictive measures, like text reminders of court dates and assistance with transportation to court. Second, as I noted, there's no evidence that it reduces pretrial detention rates. And third, part of why we know so little is because there's so little data. We don't even know the number of people who are on monitors today in California. Before I get to my recommendations and conclude, let me briefly address a question I often get asked, which is some version of, isn't monitoring better than jail? And there's no question that for a subset of people who would otherwise be detained, monitoring is better than jail in some cases. But because we have no data, we don't know if monitoring is in fact being used on people who would otherwise be in custody or remain detained. The concern, of course, is that monitoring is often used on people who would not or should not be detained. More often than not, monitoring is used in addition to jail. People often spend 24 to 48 hours, as we've heard, in jail before being released on a monitor. So that means they experience both the harms of detention and the harms of being on a monitor. And of course, many people cycle in between these situations because they're redetained for technical violations. So it's rarely as simple as one day on a monitor versus one day in custody. People often experience both. Finally, the justification that it's better than jail is a low bar and fails to limit the harms associated with monitoring. Let me conclude with a few brief recommendations, and I say more in my written submissions. So overall, I think monitoring is used too much, and it operates in ways that replicate the harm of pretrial detention, even if to a lesser degree. So 3 ideas for reform. First, limit the use of pretrial monitoring, both in terms of who is subject to monitoring and how the monitoring operates. Monitoring should only be used if there's no less restrictive option. If imposed, monitoring rules should be no more invasive and restrictive than necessary. Second, eliminate detention for technical violations of monitoring rules. People should not be reincarcerated for rule violations. And third, there's a real need to collect and analyze data. And I should just say that California is already taking steps in this direction. And I just want to highlight 2 recently enacted laws. AB 1228 limits detention for people arrested for probation violations. And similar legislation could limit detention for monitoring violations. AB 2658 limits the use of electronic monitoring in juvenile court, including a prohibition on devices with audio features and required data collection. And there's also model legislation out of both Illinois and New York, and I'm happy to say more about that. But I'll end now, and I look forward to your questions.
Thank you very much. Thank you all. That was helpful. Professor Weisberg, I think we all agree that the promise of electronic monitoring is it's an alternative to incarceration, right? Is there a way, I mean, and the concern, and I think it's, can you at least go through the data that you're pretty confident that we're not replacing incarceration with ankle monitoring? Is that instead we're increasing monitoring of people who would otherwise be released anyway? Is that your conclusion?
Well, certainly based on the data we have, and the data is very limited. The concern is that,
sorry, what data do we have? And yeah, tell me, go.
So it varies greatly. To some extent, we're seeing that monitoring is expanding in use while the jail population stays the same. And in other places, we're seeing that monitoring is increasing in use while the jail population is also going up. And in other places, we're just seeing, and this is beyond California, we're just seeing monitoring being used in sort of no real effect one way or another. We just don't know. So I don't know if we can say I think that monitoring is replacing detention, but perhaps it's not necessarily, there's a problem of just both who is placed on monitor and how monitoring operates. I think it's a twofold problem.
I have a question, Mike, if I might.
Go ahead. Yes, please.
On this issue of electronic monitoring. When I was on the trial court, I think one of the considerations about electronic monitoring that was presented was just the daily cost. So if you're dealing with someone who doesn't have the resources, I'm wondering, one, what are the daily costs? I'm sure they vary throughout the state. And second, are there ways of sort of adjusting the hours on which one is monitored, where someone in pretrial detention via electronic monitoring would have leave to go to work? So those two issues always came up, and I wonder if the professor has a response to those two things.
Yes, those are excellent questions. So first, with respect to the fees, thanks to the work of the Policy Advocacy Clinic at Berkeley, in California, there are no fees for electronic monitoring. And my understanding is that most counties are no longer collecting fees for electronic monitoring. That being said, there are other financial burdens associated with electronic monitoring. So for example, paying for electricity and having access to electricity, paying for a cell phone or landline, and also absorbing the other costs associated with not being able to do things like take care of family members or go to job interviews as easily. So there's sort of collateral financial costs of being on a monitor.
Right.
And then with respect to the ability to leave, this is where some model legislation in both Illinois and New York is great, where there's a presumption that people can move about and live their lives without being subject to house arrest. And certainly I think there are more creative ways of using electronic monitoring than is currently being used. I mean, right now it is used as sort of an on-off switch. You're either incarcerated at home or you're not. And I think that there are more creative ways of sort of calibrating the restrictiveness of electronic monitoring.
Okay, yeah, those are issues that came up. Mike, I also have a couple of questions for Ms. Vidianti, if I can proceed now.
Of course, yes, no, go.
Ms. Vidianti, you went rather quickly over some of the statistics, and I just have a couple of questions with respect to that. And on the failures to appear for people who've been released on their own recognizance, do you have those percentages for the pre-pandemic and then also post or pandemic periods? I thought I heard 36%, and it seemed like there wasn't much difference in the two.
Yeah, so the rates that I was citing were for cumulative rates for all pretrial releases. So this includes OR, side releases, bail bond releases, and other type of releases. In the written submission, you would also see the charts for monthly rates of FDA, which vary over time. But if you are looking for cumulative rates for failure to appear in court for, I think you mentioned own recognizance releases specifically.
Right.
So for the 3 time periods that we're looking at, so those starting in 1 year pre-pandemic as well as in year 1 and year 2 post-pandemic, the rates respectively are 39%, 47%, and 44%.
So the numbers, the failures to appear went up evidently during the pandemic when presumably more people were released on their own recognizance.
Yeah, so it's actually a little more complicated because if you recall, I mentioned that upstream, the number of people who are arrested in the first place actually went down, but the rates of releases among those who are arrested in this pretrial period actually went up. So in terms of the numbers, I happen to have them here. In those 3 time periods, the number of own recognizance releases are about 20,000, 20,000, and 16,000.
Okay.
So in year 2 of the post-pandemic pretrial population, we actually have fewer OR releases despite a higher rate of OR releases just because there were fewer people arrested to begin with.
Okay.
In terms of the FDA rates, there was a significant spike, I should say, in terms of the monthly FDA rates for own recognizance releases at the beginning of the pandemic. The
Right.
rates actually stabilized over time. The cumulative rates and the monthly rates have a relationship that is a little difficult to really explain, but it does seem that the FDA rate has decreased somewhat from what they were when we were looking at the cohort in the first year
First year.
after the pandemic. Yeah,
Okay,
but
the
it
second
is
question I
currently
had-
still higher.
I wonder if you could also address the rearrest rate. I think you went through that quite quickly and they didn't have those. I couldn't
Sure.
follow that.
So we are looking at rearrest for new offenses specifically. So we try to eliminate rearrest due to probation or parole violation,
Right.
as well as bench warrants due to FTEs, for instance.
Mhm.
So when we're looking at all pretrial releases, the rearrest rates are 35%, 40%, and 32% respectively for these three cohorts. If we are looking specifically at OR releases, they are 25%, 37%, and 28%. So there's a spike and then it goes down again,
Goes back down. Okay, all right, that's what I wanted to get. Thank you.
of course.
Other questions? Professor Campos-Bouy, I have a question for you. I think we were all very, well, maybe not all of us, I was pretty optimistic, perhaps, about Humphrey and the data that you presented and that we've been hearing, throughout today is that not much has changed. Is that the upshot? In order to codify, let's say to codify Humphrey, first of all, do you think that would be helpful? How would you do it? This is the same question I asked Dean Chemerinsky. I'm not sure if you were here for that part, which is I'm not quite understanding, maybe it's a misunderstanding terminology between presumption of no money bail and a zero bail schedule. Can you unpack that a little bit, Paul, for me? How might you codify, if you think useful, how might you codify Humphrey to make it as effective as possible? And if you could explain this zero bail schedule idea.
Yeah, so I mean, I think codifying is helpful to compare at least to other states. I think California, we're in the minority of jurisdictions where there's not a codification of presumption of release. And so there are a number of states who do it for both misdemeanors and felonies. And I believe in California, we only do it for misdemeanors. So I think there's room to develop there. As to your question about
Let me just stop there.
Mhm.
So most other states, there's a legal presumption of release without money bail. Is that correct?
It depends on there's a number of different ways in which they're categorized, but the National Council of State Legislatures has kind of a breakdown of the ways in which different states are doing this. And there are a number of states that codify a presumption of release.
Okay.
As to your question about kind of zero bail versus presumption of release, I mean, I think, it's interesting to see the use of zero bail during the pandemic and the impact that it's had. I mean, I think part of it too, and maybe this isn't answering your question entirely, but I think regardless of what the reforms ends up being, it seems that there continues to be workarounds of what is in state law, what's coming out in case law. And so to me, it's almost like regardless of what ends up happening, the compliance, the monitoring, the tracking seems to be where the focus should be. I think, we've moved forward a lot on a lot of reforms in California, but I don't think there's necessarily the pressure or the focus on following up on that, in part because I think there's not tracking at the local level of what's happening. And so when you ask questions about would X happen or would there be an outcome from Y, we get the answer of we don't have the data to speak to that. And so it's frustrating to, move forward in this space when we're kind of almost plagued by the lack of an understanding of what's happening in practice.
Sure, I get that completely. And we really try to be as data focused and
Right.
evidence-based as possible. That said, magic wand time, if your first step would be to collect the data, or would it be to what would your first step for if you could recommend the legislature what to do here?
I mean, at this point, given what we were hearing from public defenders, from the records, I think it's, resolving this question of Article 1 or Articles Section 12 and 28. I think that is causing a lot of confusion and headache at all levels. And so that's kind of where I would start if I had a magic wand and provide clarification on that.
Sure, and I understand that and how, let's say we clarified it, how would that improve the system? I mean, I understand it would just avoid confusion, but how does it materially impact all the negative impacts that we've been talking about today?
I mean, I think part of it comes down to, frankly, judicial discretion, and I'm interested to hear the upcoming panel about kind of what role judges are seeing now and what role they would like to play, because I think honestly, regardless of whether we have a zero bail schedule or a presumption of release, if judges are finding other mechanism or ways to get around that, we can dream all we want and pass all the legislation. And so that's what I think what we're seeing here in Humphrey is, we all thought that it was a pretty clear, you can't, imposing bail that, people can't afford is unconstitutional. And yet we see people turning to Section 28, in part because I think the Judicial Council put out some pretty strong trainings leaning in that direction. So to me, judicial discretion is kind of where the conversation should be happening.
So in other words, if you're concerned that if we were to say, okay, presumption of release or presumption of zero bail, it's just a presumption that the judge can say, well, I've overcome the presumption, and so they're too dangerous to be released. So I'm going to.
Right. Yeah, and I think you mentioned this earlier. I think we've seen a lot of, dangerous coming into the conversation. And instead of saying, I'm holding you because I see you as high risk, or that's what they're saying, I want to hold you as high risk, but I can't do that. So I'm going to set an enormous amount of bail. So practically you can't get out.
Right. That's certainly something that I'm concerned about. And I was curious if you had, I've asked a lot of people this question, but if you had concerns or reflection on this idea of, court-backed bonds as opposed to relying on the bail bonds industry, would that address many of the concerns, at least the financial concerns that we're talking about?
I think it's a good start and gets at a lot of, the current headaches and harm that's happening. I do think we should still be questioning what the role of money is playing in the system, and who it's actually, getting people to come into court and show up, and who it's negatively impacting. I think we continue to know that 80% of people in California cannot afford to pay bail, predominantly Black and brown people. And so what are we actually doing with money in the system? And so, yes, I think it gets us moving in the right direction, but I think we could still be challenging ourselves to understand what role money is actually playing.
So, yeah, and I agree. And, one of the problems we have is, of course, Prop 25, which we alluded to earlier, right? You can't completely, that's constraining things. Before we move on, does anybody else have any questions? Yes, Senator Skinner.
What state, and this to any of the researchers, would we now say is kind of the model? I mean, the notion that all other states have some alternative bail is not accurate, at least in my looking closely at other states. But there are certainly states better than California right now, as you've referenced. But what one or two states would we look to right now as the model?
I can start. I would say Illinois is a good model with respect to pretrial release and the use of electronic monitoring for pretrial release. There is a presumption of movement. There's a limit on how long someone can be on a monitor. And there's been some just pretty incredible advocacy efforts in Illinois to reform the use of electronic monitoring. So I feel like they're sort of further along in the sort of advocacy and reform with respect to pretrial electronic monitoring.
Okay, so that's on monitoring, but what about in general on the whole bail question? And
I think there are just elements of I wouldn't necessarily call any state a model at this point. I think each state has, different elements. I think Harris County, I know that's not a state, but is doing some interesting work. New York, I think, was going in the right direction before.
What particular from Harris, like really, what's particularly appealing about what's going on in Harris County?
I think, it's interesting to see some of the elements that are playing out, but I think some of the outcomes that are coming from that, kind of changes in the kind of, I think, racial disparities that are happening there. I think it's just worth requiring or digging into more. And I think part of the challenge too is a lot of these reforms are fairly new and evolving and happening during the pandemic and other things. And so I think it's hard to isolate necessarily what element of particular reforms are leading to changes, or if there's other things happening in those jurisdictions.
When you said that New York is going in the right direction, are you indicating that they started reversing, or elaborate a little more on New York?
So my understanding is they passed a law and then ended up taking some additional amendments that kind of redirected the course, and that, had a pretty significant impact on, I believe, kind of release rates and other things. And so kind of just, the legislature took a different direction.
So New York is not necessarily one to look at right now?
Not right now, but I think where they were going is something to re-examine of what they initially had introduced.
Okay. The reason I raise it is not that California has to have a model elsewhere, but given that we have had these pretty severe fits and starts in this issue, I never say never, but I think it's hard without somewhere else having paved a path for us that we can show more, give legislators and the administration, more security or more whatever. So just a perspective I'd offer.
If I can just
Yes, please.
offer a different perspective. I'm not a legal expert, and I'm not going to comment on which state is a good model. But I just want to bring up the fact that I think we do need to take into account the role of law enforcement in this whole process, because in our data we saw that the way that the law enforcement agencies have responded to $0 bail, from what I heard from the law enforcement agencies, and this is also borne by the data, is that they simply arrest fewer people. And, especially for misdemeanors, as I mentioned, the number of arrests have actually halved. And that really had significant ramifications downstream as well. So, I don't really have a recommendation per se, but it does seem that if we can actually affect the pretrial landscape upstream, that in terms of volume, that's going to really significantly affect the number of people who are, we're talking about releases, but in the first place, we actually see so many fewer people being arrested in the first place, which I think is really the ideal circumstance. And we are also seeing that for misdemeanor in particular, the increased releases for OR and cite-and releases did not have an impact on public safety.
Right.
Can I just say,
Go ahead.
sorry, I just want to say one other thing, which is that California in many respects is a model for other states. So I just want to point out that with respect to monitoring, for example, when people ask me, is there a state that you can point to that has done any legislation with respect to electronic monitoring in juvenile court? California is the only state. And so I don't want to lose sight of the fact that California has been and can continue to be a leader in how electronic monitoring, at least, and that's just my area of expertise, can be used effectively.
Well, thank you all. We have to keep things moving. I really appreciate your time, your insights. Again, as I said before, no good deed goes unpunished. I'm sure we'll be back in touch with you. Please be in touch with us if there are things that come up during today or that you hear about that you think would be helpful to us. We really appreciate it. Thank you all for your time. It was good to see you all. Next, we're going to be joined. Are we ready to move on, Tom?
Yeah, let's do it.
All right, next we're going to be joined by Kendra Zoller, who's the Deputy Legislative Director for the California Department of Insurance, and Andrew Gulcher, I hope I pronounced your name correctly, Regional Supervising Investigator at the California Department of Insurance. Ms. Zolcher will give an 8-minute presentation about the Department of Insurance perspective on the bail bond industry, and we'll have also have some time for Q&A. Sculpture, take it away.
Hi,
I'm sorry.
no, that's okay. We're both presenting. I think Andrew's on. Oh, there he is. Hi. I'm Kendra Zoller. Like you just mentioned, I'm in the legislative office of the California Department of Insurance. I'll kick it to Andrew to introduce himself.
Good almost afternoon. Andrew Gulcher, Department of Insurance. I'm responsible for all licensee bail investigations of those who transact bail, and also de facto fugitive recovery persons investigations on those people hired by bail agents. I have oversight of all open and previous investigations.
I'm going to share my screen to get this quick PowerPoint that I will try to go through very quickly. All right, can everyone see that?
Yes.
Good. All right. It's very common for people to not know that the Department of Insurance regulates bail. It is in fact an insurance product. So just a quick overview of our regulatory role is on this slide. We review the rates that the insurance companies, they're known as sureties, charge to consumers. That is under Prop 103, which means we have to review those rates for fairness, and we approve them ultimately. We also license the bail agents, and next year we will be licensing bail fugitive recovery agents, also known as bounty hunters. We have a market conduct division, which does exams of the insurance companies to make sure they are following the law. We do administrative cases to take away the licenses of bail agents or bounty hunters. We have the enforcement division, which Andrew just discussed. We also kick cases to DAs for prosecution on bail-related cases. We also have a consumer services division that consumers can call if they have complaints about their bail bond contracts or the activities of the bail agents that we try to resolve. And lastly, we have a premium tax unit. There's a 2.35 tax on the insurance premiums, which we collect, but they ultimately go to the general fund. And I'll go to the next slide here. I included this because a lot of people do not understand how the charges of the bail bond work. They are typically 10% of the total bail amount. Then the bail agent pays the insurer 10 to 15% of the premium. The surety pays the premium tax, which goes to the general fund. Hopefully this is not too confusing, but I'll try to go quick and we can do questions later. There's also a thing called the build-up fund, which the bail agent pays into on each premium. The surety holds this fund, and that is used if there are any skips, so that the surety ultimately rarely has any losses because they hold this account that they make the bail agent pay into regularly. At the end of a bail agent's career, that is often their retirement account. The rest of the premium is commission for the bail agent. So that's a pretty large amount. Another thing to note, because bail is under Prop 103, a bail agent can rebate part of their commission to offer a lower percentage rate to a consumer. 8%, 2%, some even do 0%, which we will discuss in a little bit. And they are allowed to do that because surety is under Prop 103. Unless a bail agent surrenders a defendant back to jail without good cause, bail bond fees are non-refundable. One thing to note there is they will often lie about the reason they are surrendering someone so that they do not have to refund the amount to the consumer. We can talk about that later too. And a bail agent may additionally require the bond to be secured through collateral. However, that is not required, but they are supposed to do that because it is a way to underwrite the risk. That can be through a lien on a house, assets, etc. Wanted to know another side of how the money works here. When someone skips on a bond and how a bail agent or surety may end up having to pay the court. The court will first go to the bail agent for the entire bail amount. If they do not pay the court or fail to return the defendant, they will go after the surety. The surety will then go after the bail agent. And ultimately, if the surety does not pay the full amount, we can take action and disqualify them from posting bonds. But because the way this all works in the penal code, it's very, very complicated. The procedures are kind of a mess. They usually get out of it. You can ask the counties about that. There's millions of summary judgments that bail companies have not paid. Including if this all happens, there's a 2-year time limit. So if this is still ongoing after 2 years, they get out of it. So unfortunately, that is how that is set up. So wanted to note that. Here I've included the total bail premiums written in California from 2015 to 2021. This is interesting because you are probably aware of the $0 bail during the pandemic. And as you can see, the money didn't really change too much here. We've heard anecdotally that this is largely because they made a lot of money off domestic violence cases. And clearly, we don't have enough data to be able to interpret this, but it is very interesting. Finance bail, I'm going to kick it to Andy for a minute to talk about the cases in this area. I'll just quickly say that, like I said, the bail agent can rebate part of their commission to give a lower rate. And what we've seen that the bail agents have started doing is allowing people to use credit cards, referring them to, loan companies. They've come up with all kinds of ways to help people finance the payment. But what happens is they get in very bad financial situations. The bail agents will send this to collection companies. They're charging interest when they're not supposed to. This is kind of a new thing that's come about, and I'll kick it to Andy to talk about the cases we have seen.
The finance bail is definitely an emerging trend for predatory behavior by licensed bail agents. Many times they are taking less than 10%. They'll bail somebody out with whatever they can get that day out of an ATM, and then sort of arrangement of cashing a check in the future, or come by the office and drop off $300 once a week. Many times family members are signing these agreements on the behalf of a family member or friend typically, and what ends up happening is they turn these agreements over to what she mentioned was third parties, and then bringing small claim suits against the parties. And there have not been proper disclosures made. Department of Insurance has partnered with the California Department of Consumer Financial Protection to try to mete out some of these agreements, whether they need a license to finance bail, to even offer it, to see if they're in compliance. And we have active open investigations with that. We also have an open investigation with the City of Los Angeles City Attorney's Office on this predatory behavior, because it's impacting people most at risk, and it's usually the family members who maybe don't have a lot of money to begin with. And we've also got a federal investigation with the federal financial protection agency with the state financial protection agency, looking at the conduct that we largely believe is unethical and unlawful. And then on the next slide, these are the typical types of complaints. We've been doing more of a roadshow and outreach with local law enforcement. Most police agencies don't understand bail and what licensees and recovery persons are allowed to do. We've had some very recent high-profile cases, namely Palm Springs, where a felon shot and killed a misdemeanor person who was not wanted for anything, that they were trying to what we call 1300 or turn back in because they thought the underwriting risk was changed. We had two former police officers in Orange County that we've indicted for kidnapping, where they will take a cosigner on a skip and kidnap them and drive them around to try to find where the person is at. And we just had another one in San Diego with National City Police Department where the same thing was done. We certainly have seen the theft of monies where they take more money than they're supposed to. And we've seen a lot of, and we've historically had unlicensed activity and jail capping where we have law enforcement actually getting paid to refer certain specific bail cases to licensees, such as DUIs that are complaint of pain, where the bail can be very high, but if they get in front of a judge or can call to have the bail reduced, they may have been released OR, but sometimes there's this feeling that they have to get out immediately, fostered by internal inmates or law enforcement inside getting paid. Where we work a lot of internal affairs cases to try to prevent that. So those are typical cases that we get regarding licensees. That it's difficult because our complainants, our victims, are often seen by the criminal justice system as not having any credibility. And a lot of times they don't feel like I have the voice. And so we have to build trust first and then, hear what their story is from their friends and family. So they feel like, yeah, you were wronged. This activity is unethical and illegal. I think it's to you, Kendra. Mute.
Ms. All, are you going? We can't hear you.
Are you muted, Kendra?
Mr. Gulcher, do you want to try to take on the recommendation piece?
Yeah, sure. So we've had a number of recommendations and reforms that we've.
I think I got it.
Okay.
I'm sorry, my computer's playing tricks on me.
No worries.
I'm sorry to cut you off. I just wanted to say that these recos come from a report we did in 2018, except for the last one. First of all, our last commissioner and our commissioner now do support bail reform overall. We've tried to be part of those conversations, but we also want to do things that help consumers now who are still dealing with abuses in the system. It's kind of a hard, fine line for us to walk because some of these things, such as, stopping some of these financed bail practices, advocacy groups don't like them because, some of them do help people without money be able to bail out, but we also don't want them to get in bad contracts with, taking out bad loans and paying more than they should for these bonds. So it is kind of hard for us to do that, but I just wanted to put that on the outset. So these are just some of the reforms that we came up with through our experiences. Some of them have failed. We've tried them all almost, I think. Some of them have passed. I'll go through these really quickly. The way our enforcement works for all types of insurance at the department is usually a fee on an insurance contract, except for bail. Bail has no enforcement fund within CDI, unlike all other lines of insurance. We would like to have better funding for that, but it could ultimately be paid by policyholders. So that is a little bit difficult for us, but it would be better. We could do better outreach, but more cases. Bounty hunters are unlicensed in California, but we were able to push through legislation this year. They will be licensed July 1 next year. One thing I noted earlier, this is in the penal code, is bail agents are not allowed to surrender people back to custody because they didn't pay their premium. But what they do is they just claim flight risk so that they don't have to return the premium to the consumer when they bring them back to custody. They call it premium chasing. Our thought was bail agents should have to obtain an arrest or bench warrant prior to surrendering so that we know the reason why and there's record of it. Also, similar to how there's no enforcement fund for bail at our department, there is nothing that requires surety insurers to have like a fraud unit. We have that for other types of insurance. So if they did have that, there would be better internal policing, and they would have to send more cases to us with better data, better enforcement. Bail agents have to have a surety bond prior to licensure. It's in California, I think it's $10,000, which is extremely low compared to other states. Technically, consumers can collect on those bonds if they're harmed. So we think that amount should be increased. Similar to all other lines of insurance, bail did not have any disclosure. So consumers did not know they could call us, the department, if they needed to complain or if they needed help with something. We were able to get that into our omnibus bill this year. So that's great. Clarify the bail term limits. We were able to get this done last year. This was a terrible thing that they were doing. They were charging the premium every year if the person's cases were continuing on, which they are not allowed to do. It's a one-time payment. They were especially doing this on immigration bonds, but we were able to include that in the bill too.
I want to cut you off just in the interest of time for a second.
Okay.
I hope that, first of all, if you haven't already submitted these, please, make sure that we get all this, these recommendations, because they're super helpful. Mindful of the time and next panel, which is already ready to go.
Yeah, sorry, it's hard to go fast.
No, it's okay. We're trying to pack in a lot, and we asked, you guys to condense a lot of information. I just have, one quick question, then I want to see if anybody else. Is there any concern from either Prop 103 or any other concerns that your agency might have if the courts just did this instead of the bail bonds industry, meaning instead of having to post bail in advance, that it would just be a court imposing a bail, imposing the amount of bail if somebody skips?
I don't think so, because it would no longer be an insurance product. So I don't think so. I mean, we could definitely share some of our consumer protection ideas to help make sure you've got those in place as well. But otherwise, I don't think it would matter to us.
All right. Thanks a lot. Like I said, I'm sorry to rush you, but we do want to keep everybody on schedule. We have a bunch of judges who actually took adjournment from their calendars on our next panel. So we want to make sure that we get that. Senator Skinner, before
I have one question that,
of course.
So either Andrew or Kendra, doesn't the department have the ability, do you have to have us change the statute for you to include in your, because you set the rates, for you to include an increase in rates in order to cover certain costs of enforcement? I mean, in other lines of insurance, you all can adjust rates to cover enforcement. I'm trying to understand why you'd need us to do it by statute for you in relationship to the bail, since it's already your purview to regulate it.
Well, like for auto, workers' comp, health, whatnot, it's a charge like $1, 1 cent. I forget what some of them are. Andy, you might know from the enforcement branch, but like per policy. There's not, and that's all in statute. There's nothing for bail.
Right.
We just have our licensing fees. So, I mean, I guess through like a budget process type of thing, but
Yeah, but I think it'd be worth it for the department to really look at existing statute in terms of authorities that you may have that you may not be fully utilizing versus just relying on the legislature to either budget it or change a statute. I just would recommend that.
I think that's a great idea. I guess we are thinking the fund, because part of the money goes to DAs and then we can push them to prosecute the bail cases. Sometimes they don't always take them up, but definitely will note that. Thank you.
Sure.
Any other questions from committee members? Ms. Zoller, Mr. Gulcher, thank you so much for your time. We really appreciate it. And I think we're ready for our next panel. Thank you. Have a good afternoon.
Thank you.
Yeah, I'm getting everybody coming on board. You can get started, Mike.
All right, our next discussion will be joined by 4 Superior Court judges from counties around California, including 2 who are on the Chief Justice's Pretrial Detention Working Group. Our panelists are Judge Lisa Rodriguez from San Diego County, who was on the Pretrial Detention Working Group and is also Vice Chair of Judicial Council, the Committee on Law Enforcement, Committee on Criminal Law Advisory Committee, excuse me. Judge Richard Cousins for Placer County, Judge George Eskin from Santa Barbara County, who was also in the Pretrial Detention Working Group, and Judge Brett Aldridge from Tulare County. We'll hear from each of the judges for 5 minutes and then have a Q&A afterwards. Judge Rodriguez, can we begin with you? Oop, you're on mute.
I'm happy to speak first. I didn't actually prepare anything. I wasn't aware that we were going to make.
All right, we could jump
statement.
right to Q&A. If you waive your time counts.
I'll waive my time.
Oh my gosh.
And I'm happy to answer any questions.
Terrific. We really appreciate you having here. Judge Cousins, you want to go next?
Thank you very much. It's my pleasure to be here again to talk to you. I just want to point out the materials that I supplied your committee is a training document that is alive and well. It's been updated as of May, and that's the version you have. We'll be using it for a training session we're going to be giving to the bench in January through the presiding judges gathering that occurs every year. So we expect to drill down a little bit more fully for education for the Humphrey issues and so forth. It's very much on our radar screen, and we're happy to participate with you here as well. Thank you.
Oh, great. You judges are good on the time. Judge Eskin.
Can I have Judge Rodriguez's 5 minutes plus the minutes that Judge Cousins didn't utilize?
Motion denied. I'm sorry.
Well, I wanted to say hello to Senator Skinner and report to her that Hannabeth and I just returned from the Galapagos Islands, and I wanted to say hello to Justice Marino, who worked with me in the city attorney's office in Los Angeles 45 years ago.
Hi, George.
I have prepared some remarks to supplement the written material that I sent. I wanted to thank the committee for its work and the opportunity to present my opinions. I've reviewed what I consider to be an excellent staff memorandum, 2022-10 bail, pretrial release from related matters. It served as a reminder of the work that Judge Rodriguez and I invested in the pretrial detention reform work group 6 years ago. Deja vu all over again. The introductory section of Justice Cuellar's opinion in the Humphrey case identifies a major aspect of the obstacles in pretrial detention reform. He wrote, "The common practice of conditioning freedom solely on whether an arrestee can afford bail is unconstitutional. Other conditions of release, such as electronic monitoring, regular check-ins with a pretrial case manager, community housing or shelter, and drug and alcohol treatment, can, in many cases, protect public and victim safety, as well as assure the arrestee's appearance at trial. It's that phrase, "in many cases," that identifies the risk associated with the decision to release a person who's been arrested, and risk-averse judges are reluctant to subject themselves to the optics of public opinion that people who present a threat to public safety are released from custody. The challenge that we all face is to influence a change in a culture that does not understand the reality that nearly all of those who are incarcerated will be released from custody today, or tomorrow, or next week, or next month, or next year. And the focus should be on their reentry. The committee cannot resolve the fundamental conflict between the presumption of innocence and the assumption that the person's been arrested on probable cause is likely to be convicted, because not more than 90% of those who are charged with having committed criminal offenses do admit their guilt at some stage of the proceedings. Conviction of an innocent person is rare, but pretrial detention does influence a decision to admit guilt for an offense with more severe consequences than the evidence may support. And pretrial detention does have a profound impact on employment, housing, and a variety of human needs. The committee should, at a minimum, recommend codification of the Humphrey decision to replace the current statutes related to bail and pretrial release, starting with Penal Code Section 1269B. The committee should recommend adoption of a uniform statewide bail schedule with reasonable amounts of security to replace the excessive, arbitrary, and inconsistent schedules currently set throughout the state. The committee should urge adequate funding for programs designed to address the fundamental causes of pretrial incarceration, unemployment, homelessness, mental illness, and drug addiction. And the creation of pretrial services throughout the state has been an extremely important development. Whether or not that should be in probation departments, whether it should follow the Santa Clara model, which I think should be the standard for the state, I really don't, I have mixed feelings about. But the majority of county jail inmates throughout the state, throughout the country, are serving their sentences before they're convicted. And relatively few of them will be incarcerated in state prison. So another thing that I think we should take a serious look at is the definition of felony versus misdemeanor, which I think I mentioned in my written submission. Before the enactment of the Public Safety Realignment Act, AB 109, it was easy to identify felony offense was an offense that's punishable by imprisonment in state prison. Now we have this muddled situation where a felony offense can be something that is subjecting the person to multiple years in county jail. When it was state prison versus county jail, I think the public optics could understand that people who are going to state prison are those who represent the risk factor that's so much greater. But a judge now is facing bail decisions, release from custody decisions in misdemeanor offenses where there has been credible threats of potential violence to the victims, especially in domestic violence cases and in drunk driving cases. I think these are the two big ones where we, as judges in the trial court, have the problem. A DUI case where a person has multiple offenses and high BAs, you're reluctant to release them from custody unless you have the assurance that they're not going to drink more alcohol, and you can prevent that from happening. In the domestic violence cases, you're reluctant to release somebody who's charged with a misdemeanor offense, but they've made credible threats of continued violence against their spouses or partners. And that's the dilemma that we face. And like the report advises, I don't know that there's been much of a change despite the efforts of Judge Cousins and Judge Rodriguez to educate the trial court judges. We are risk averse. We do not want to have the responsibility of releasing somebody from custody who's going to go out and do something horrendous. And that's the problem we need to deal with. And that's why I believe not just education and training by Judge Cousins and Judge Rodriguez, who are wonderful at it, but I think we need some statutory guidelines, and that's why I recommend codification of Humphrey.
Thank you. Judge Aldridge? You're on mute.
How about now?
Great.
Thank you. Mr. Chairman and distinguished members of this august committee, I am honored to appear before you today, along with my judicial colleagues, each of whom have earned the highest levels of respect statewide for their experience, judicial wisdom, and commitment to justice in California. My name is Brett Aldridge, and I'm a judge in the Tulare County Superior Court. My assignment for almost a decade has been exclusively to a felony pretrial department, and my submitted written statement reflects my daily experiences as well as those of my colleagues in a system that remains entirely built upon a wholly undefendable male bunny practice that continues to be propped up and endorsed every day in every courthouse of this state. Almost 60 years ago, then Attorney General of the United States, Robert F. Kennedy, believed that the systemic injustice of a money-based bail system was so abhorrent that he personally requested to testify before the United States Senate Judiciary Committee. I have read his entire testimony many times, but will only brief the following. He testified that bail only has one purpose: to ensure that a person who is accused of a crime will appear in court for his trial. The purpose of bail is not punishment. It is not harassment. It is not to keep people in jail. It is simply to guarantee appearance in court. In practice, however, bail has become a vehicle for systemic injustice. Every year in this country, thousands of persons are kept in jail for weeks and months following their arrest. They are not yet proven guilty. They may be no more likely to flee than you or I, but nevertheless, most of them stay in jail because, to be blunt, they cannot afford to pay for their freedom. The Attorney General concluded, what is the justice in a system which, between either jail or freedom, can leave that decision up to a private businessman? The highest law enforcement official in the country knew that this was so obviously wrong that he felt compelled to offer his own unreserved testimony to Congress. Yet, here we are today, convened over a half century later, with California having almost nothing to show for by way of any measurable improvement or reform in this area. 58 years later, and millions of unnecessarily incarcerated Californians. Maine, New Jersey, New Mexico, Illinois, Kentucky are among those states that have positively transformed their admittedly unjust money bail system. But we're meeting here in 2022 with no comparable person of statewide profile speaking with the burning injustice felt by the former United States Attorney General. No one with the same sense of urgency felt by a man famously known to feel urgent injustice and the pain of others so deeply. In the place of justice, our choice continues to offload the post-arrest decisions of pretrial detention or liberty to a business operating totally outside the justice system itself. Thousands of individuals across California are arrested every day, and for all types of crimes, including brutally abusing a domestic partner, then simply calling the victim herself to demand that she get him out within hours of the arrest. She often does. Now, who makes this decision? Who wrestles with weighing the risk to that victim or to the community. It's not an elected or appointed judge in open court, subject to appellate review or electorate accountability, but a bail bondsman working in the dark of midnight. And the risk that's being assessed has absolutely nothing to do with safety or fairness or justice. The only risk that's being assessed is financial. I am not here today to criticize the bail industry. It is simply another huge American business trying to make as much money as it possibly can. But in California, it only has one customer, the California justice system. And we have abdicated our responsibility to justice itself, to a business, and we feed that business hundreds of thousands of people from whom millions of dollars are permanently extracted. This undeniable fault, Mr. Chairman, is not in our stars, it is in ourselves. No other country on this planet countenances the offloading of justice to a for-profit industry, except for the Philippines. There is much about our system for which we should be justly proud, but this is not one of them. How do we then rise to the challenge of this hour? Because the hour is surely at hand. Respectfully, the words money, profit, and justice have no place ever being used again in the same sentence. During the course of today's hearing, you will undoubtedly hear innumerable examples of how what we have created manages to be simultaneously unfair, unsafe, and unjust all at the same time. If at the end of the day, however, this committee recommends only one thing, let it be this: that the decisions that determine whether a human being is or is not detained in a jail cell be reclaimed, returned, and reposed back to where it should only be. And that is with judges working exclusively within the judicial system itself. Thank you for your invitation to testify today. I look forward to your questions.
Wow, well, that was very helpful. I mean, I do have a basic question, Judge Aldridge, if I'll start with, if you don't mind me starting with you. Don't you have authority? You don't need to order money bail, and don't you have discretion about whether or not somebody remains behind bars?
I do once they get before me.
So you say before arraignment, is that what you're saying?
Absolutely. So the way you have it now is a twofer. You have the unsafe system in which, despite whatever they're charged with, somebody bails out on a Friday night just by paying money bail, and a judge doesn't have that person before them. And then you have the case where somebody, in fact, in that situation, it's even worse than it sounds, because if somebody's held, as you have mentioned already today, within 48 hours, they're back in front of a magistrate. But my example with the domestic violence perpetrator is they pay a $50,000 bail bond and they're given a date to appear 3 weeks later. There are no restrictions, no review, and they show up for arraignment 3 weeks after the alleged event even took place. And so certainly at that time, a judge has that authority. But it's pretty hard then to reverse what's happened already. And I can speak from that as a matter of personal experience.
Right, okay, I just want to make sure though that I understand that your primary focus is on this pre-arraignment 48-hour period. It's pretty much governed by the bail schedule, is that correct?
That's the point I was making in that example. That's exactly the one I was making.
Not just your example, but also in general, you're concerned about not having judicial discretion over whether or not somebody should remain behind bars.
Absolutely.
All right. Judge Rodriguez, you're nodding your head.
I just completely agree with Judge Aldridge that the decision about whether somebody gets released for those 48 hours is not a judicial decision. It is solely a function of economic resources. So if you can afford to pay, you can be released, and there is no judicial oversight. There's no conditions placed on somebody. And so people can get out that aren't safe, and people who are safe can't get out because they can't afford it.
There is a small exception that we need to acknowledge, and
I
that
see
is.
you, Judge Eskin. So Judge Cousins, will you go?
apologize.
No, go ahead. You go, and then Judge Eskin, then Judge Eskin. So Judge
Okay.
Cousins and then Judge Eskin.
There is if the police officer, the arresting officer, for example, is concerned about ongoing safety issues and the bail is deemed insufficient, there can be a request for a bail enhancement. So there is a small measure of an intervention before the actual appearance at arraignment, albeit that's imperfect, but there is a little bit of remedy there. But I generally agree with the comments.
And that's a little bit of a remedy because somebody can still, even with the bail enhancement, be
Right.
able to be
Post bail.
released. And 1269C also does allow the defendant through himself, a friend, an attorney to contact the on-duty judge to get a reduction for some crimes as well.
Judge Eskin.
Well, I've been sitting on assignment in San Luis Obispo and Santa Barbara counties. And I wanted to say that in response to one of the things that Judge Aldridge mentioned, I've encountered cases where people were arrested and released by the bail agency to appear 3 months later, not just 3 weeks later. It's a lengthy period of time has elapsed between the incident and the first appearance in court when that occurs. I mean, the situation can be even worse than what Judge Aldridge described, all a function of the bail schedule.
So Judge Eskin, I do want to get back to your point about codifying Humphrey. And with apologies to my other committee members if you have questions, but I do want to get back to this 48-hour period or pre-arraignment period of time. It does seem like a large percentage of people, that's what a large percentage of people bail out for one way or another. I think that you probably are aware that there's some federal courts who have weighed in on the constitutionality of the bail schedule process in that period of time. And earlier this morning, we heard from the Chief Justice of the New Jersey Supreme Court, where they have some risk assessment that happens 24 hours. It's 24 hours to 48 hours. If you want, there seems to be a tension here, right? Like you want some kind of review in order to maintain public safety, but you want to do it, you want to be able to do it quickly. And right now in California, we have this 48 hours and not on Sundays and not on holidays. So it can, so I'll begin with you, Judge Aldridge. Do you have a suggestion about how we should evaluate people in those first 48 hours, and especially if judges are to be involved? How do we do that as a practical matter?
I do, Mr. Chairman. My county has been one of the 16 counties that have participated in the Judicial Council's pretrial pilot project. And now for at least 4 years, we have a magistrate or a judge working 24 hours a day that reviews all of these arrests. And at the risk of oversimplification, nobody waits longer than 24 hours to be put into one of 3 categories. And the great number of those, upon the magistrate's reading of the charges, their criminal history that's provided to them by our probation department and our pretrial risk assessment, releases the great number of those people because they're not a risk to anyone. Happens right off the top. There's a second category in which the magistrate is willing to release them, but it's going to be on some conditions. And obviously, in any crime that involves a victim, at the very least, they include criminal protective orders, they include other things, oftentimes under the supervision of the probation department. And then you're left with that last, much smaller category. If you're including misdemeanors itself, the number of people in the hold category is extremely small. And that magistrate is saying, no, this bothers me. The level of the crime charge is too high, the person's background is too big, or their risk assessment is too large. I am going to order that person be brought before a judge within 48 hours, which is usually from Saturday to Monday. Now, the only area where I think that can be the hole in that is, as was alleged or alluded to by Judge Rodriguez, is those people can still post money and get out. And so to make that system better, if you're really concerned about bringing them before a judge, that small, very limited category needs to be detained before they're brought before a judge with a lawyer, with the district attorney present in the courtroom.
Thank you. Judge Cousins?
I would just point out that we do actually have a drafted prototype of what Judge Aldridge is talking about through SB 10. We established a mechanism for that. And I do recognize there's some issues about just wholesale reenacting that, but we spent a great deal of time working out the mechanics of that, and it embraced public safety as well as the expeditious handling. We all recognize that first 48 hours is an extraordinary critical time period. We want to maximize the release during that time period. And SB 10 facilitated that. So there is a prototype that at least is a place to start that discussion about the mechanics of the courts actually accomplishing what Judge Aldridge has adopted in his county.
And as far as you're concerned, would that component at least violate the Prop 25 concern?
I'm not familiar enough to comment on that, Mr. Romano. I'm just not, except to say that it would not be the whole process, but just we could just focus on that 48-hour period, which I wouldn't think would be a problem. But I'm not an expert on that by any means.
Got it. Judge Eskin.
Mr. Chair, I have a couple questions of Judge Aldridge. One, what impact has the practice been on the Tulare County Jail in terms of incarceration of inmates prior to conviction?
Well, your question is one I ask about every 3 weeks, and I have asked for the last 3 years, and I have yet to see any data whatsoever delivered to us either by our jail or our probation department. So although that's been highest on my priority list and I'm bothering them all the time, I have no more information today, Judge, than I did when we started this. And that's
this is one of the statewide frustrations that we have. The jail doesn't know who they have in custody. They may know who's charged with a misdemeanor. They may know who's charged with a felony, but we can't get the information in terms of how many of these people are likely to be sentenced to state prison and therefore maybe shouldn't be released from custody. We just don't know the jail population, and that's a statewide issue. I'm also interested in
we're quite familiar with the concerns about
how can we get the prototype that Judge Cousins referred to. How do we get the Tulare County practice implemented statewide? Is it going to be through legislation? Is it going to be through rules of court? How can we expand that to a statewide practice?
I'm going to defer to Judge Rodriguez. I'm sure Judge Cousins, who are very familiar, I think, with SB 129 and how the Judicial Council is preparing to implement the change in the law. So I warned Judge Rodriguez that I would probably put her up a couple of times in this presentation, but if she's ready to answer that question, I'm sure she can.
That'd be helpful.
So, I think that Judge Cousins makes an excellent point that SB 10 really gave a good framework for that. And that framework was very much based on Washington, D.C.'s and the federal system and addressing, how you can do those kind of things. Santa Clara also, like Tulare, has a really robust pretrial where people are reviewed in custody before arraignment. The money that has been given to the counties to implement pretrial isn't really designed to address that 48 hours. It's designed to address once somebody goes to arraignment, and then we're putting people out on pretrial. So if there was one thing that, you wanted to do pre-Humphrey, because Humphrey really applies once they get to the court, it would be implementing something legislatively that addressed the in custody pre-arraignment portion. And I don't think it can be done through a rule of court. I think it has to be legislative, and there has to be money that goes along with it. And I would recommend that you not limit it to probation departments. For some reason, we've been limiting things to probation departments, and there are counties that have pretrial already. There are counties that have third parties or had third parties that were doing it. My own county, we had the sheriff doing it because we lost our pretrial agency. So I hesitate to do a one size fits all because, as you all know, every county is different. We have very small ones, and then we have these really big ones. And so mandating that it be a certain way is going to be difficult.
And by do it, you mean do assessment, a needs assessment, a risk assessment, and then provide those services.
Yeah, I think having a risk and needs assessment, but having that judicial involvement, learning what somebody's record is like, the failures to appear, that kind of thing can help make informed decisions. But they also need to know about what the crime is, so that you can make informed decisions about what might be important conditions of release.
Interesting. I'm going to pause here. Do committee members have questions?
Can I add one thing?
Of course.
I did notice in your the memo that you talked about defendants not being liable for the costs. And I certainly applaud that notion. The problem is that many counties do not have money and do not have funding for those supervisorial costs. And so it can have the exact opposite intended effect, which is that people who might have been able to be released can't afford, the county can't afford it, so they keep them in custody. So I would just caution mandating that they never be able to pay for those things.
That's interesting. Judge Eskin, to get back to your point about codifying Humphrey, okay, that's easy to say. And what particularly do you think is most important in terms of codifying Humphrey? Is it the presumption? Is it a concern about how to evaluate one's ability to pay? Can you please elaborate?
Well, I haven't taken on the challenge of analyzing Justice Cuellar's opinion and seeing how do we implement this in terms, I was thinking in terms of rules or in terms of statutes. This is what the court must do before a decision is made with regard to the defendant's release from custody. But I think, I have it here. For example, I think there should be a requirement that the court consider the arrestee's ability to pay. I'm sure that's part of the protocol that Judge Cousins alluded to. It should be set forth with some specificity about this is what a judge must do when the matter is before it, when matters before the court to determine whether a person is going to be released and under what conditions. This is what should guide a judge in making the decision to release a person or deny release, but it shouldn't be based on an amount of money.
I understand. I was wondering if you all heard the earlier presentations or got to read any of the materials. Judge Rodriguez, did you have a question?
Oh, I was just going to mention a little bit about Humphrey, if I could.
Yeah, I was going to get to that, but go ahead. You go.
So Humphrey lays out a really good roadmap. And I think Brown kind of confirmed that Humphrey laid out a really good roadmap. And so Judge Cousins and I teach this a lot. I just taught Monday to some judges on this very topic. And I think it sets out that you have to ask certain questions. First, is it a public safety risk? Is there a flight risk? If the answer is no, then it's release. If the answer is yes, then will non-financial conditions be sufficient? If the answer is yes, then release with the non-financial conditions. If the answer is no, then we go to, well, will financial conditions coupled with non-financial conditions be sufficient? If the answer is yes, then it's how much can that person afford to pay? It can't be more than they can afford to pay. That I think is incredibly clear in all of the opinions. If the answer is no, that non-financial conditions aren't sufficient, then is there clear and convincing evidence that this person either isn't going to come back to court or is such a public safety risk that they need to be preventatively detained? So I think it lays it all out. The problem is that people are afraid of it. And I think everybody's talked about that. There is an equal discomfort in releasing people versus holding somebody without bail. What we're doing right now, when not following Humphrey, is constructively detaining people. It is not transparent. So if you were going to codify Humphrey, then you
Well,
should be
what do you mean by the
cautious.
constructively detaining people? So what?
You're constructively detained if bail is set so high that you cannot afford to pay it.
Right, so bail is used as, I've been saying it's a proxy for dangerousness, and so we don't go through the whole
Exactly.
dangerousness determination. I'm just gonna set a number that I know that you can't afford, so not my problem.
That we think you can't afford, but you're still bailable. You can still get out. If you can make this, then you're still bailable. So my caution again is if you want to codify Humphrey, that you have to be careful that you don't undo Humphrey, because it is winding through the court process right now, and it has all kind of gone along the same path. But there are things that we don't know. We don't know about how to figure out ability to pay. Nobody's addressed that. No court's addressed that yet. We don't know about the conflict between Article 1, Section 12 and Article 1, Section 28. It seems the cases seem to say that you could preventatively detain somebody who had failed to appear, who you really believed was not going to come back to court, making those particular findings. Codifying things like that would be helpful, but being careful not to undo what the Supreme Court has done in Humphrey.
What in particular would you be concerned about undoing?
Well, like not being careful to indicate what would be preventative detention, not being careful to indicate what would be release or going through the structure that has been laid out, making it either one way or another way. I think it's important to follow the structure that Justice Cuellar laid out.
Mr. Chairman, if I may.
Sure.
I listened carefully to the entire session this morning, and I don't recall a single panel that was not asked to respond to your inquiry. And that is, why is it after what Judge Rodriguez and Judge Cousins have all acknowledged, Judge Eskin did the same thing, that the Supreme Court decision in Humphrey was pretty direct. And why is it a year and a half later, we're finding these examples of it just not being followed? And to do that, I sort of have to address an uncomfortable truth that nobody seems to really want to talk about. And to do that, I have to just make a brief reference as to what happened or didn't happen with SB 262. And so by the time that bill, a couple of weeks ago, finally reached its final end, it had been pared down to almost nothing. And despite that, it didn't pass. And what I noticed about that was that I counted 19 assembly members who abstained from even casting a vote. And what my colleagues and I have to do every day, we don't have the luxury of abstaining. They have to face the public every day to defend their pretrial decisions. And if an elected historic majority are unwilling to support that type of legislation that would allow judges to rely upon them, then you have each judge sitting worried about the most feared headline in the world, which is judge released person who committed a murder. Now, if one of my colleagues is so good that she's right 99.9% of the time, nobody reports on the counterfactual that 999 times out of 1,000, she made the correct decision. She returned the gentleman or the woman to their families, to their jobs, back to their communities, and saved everything. That's never reported. But the one time out of 1,000, and I'm not talking about a bad decision, I'm talking about a bad, unforeseeable outcome. That headline says, did that judge decision lead to a murder? I've seen the headline, I read it all the time. And that's what passes for public discourse on this issue. Judges have to have the support, either through constitutional amendment or very straightforward statutory support to be able to make a tough decision without having their entire career perhaps on the line, because they too have to run for election every 6 years. Thank you.
I couldn't
Mike-
agree more
Mike, I
with
do have
Judge
a-
Aldridge. His comments are right on point.
Yeah, Mike, I have a comment if I may.
Yes, Justice Marino.
Just, I think four comments. First of all, I agree completely with Judge Aldridge that really, a trial judge is heavily focused on that extreme possibility that someone released on either on bail or on OR commits another crime, and you're the headlines the next day. Couple of other points. I agree with Judge Eskin that, you know, fundamentally, there's a tension between presumption of innocence and the public safety and failure to appear considerations. And that's something that perhaps we as judges understand, and judges don't need any further education on that doctrine, but certainly the public does, because the presumption is if you're in court, you know, where there's smoke, there's fire, that, you know, presumption of innocence really just goes right out the window. So I agree with that comment. Third, you know, on the question of Humphrey, you know, that presents a matter of constitutional interpretation and application between section 12 and 28 F3. I think I read that the court has asked a lower court kind of to address that issue in the first instance. So unless and until that is done, codification of Humphrey, if it's going to deal with those two competing factors or standards, that I wonder if codification will alleviate that issue. I'm really, lastly, I'm really intrigued about, you know, that 48-hour period, you know, where I mentioned earlier that, you know, families go into a panic and they do raise bail and a bail amount to their great sacrifice, so that you really have an unregulated period of time where there's no judicial involvement, as was pointed out. And I'm just wondering if, I think there's reference made to certain programs that look at that pre-arraignment. And I'm just wondering what the expense of that is and who's involved. Is it probation? Is it a unit within the police department? Is it a third party that makes those early determinations to release people, release arrestees, OR? It's one thing for maybe the bigger counties to be able to fund that, but I wonder if there's some kind of state funding for the expense of funding that kind of pre-arraignment review and release, because that would kind of head off a lot of the concerns that we're talking about right at the pass at the very beginning of the process. So those are my comments, and I think if anyone has any information on those critical 48 hours, I'd like to know.
Would the financial pain experienced by so many people be ameliorated if the bail schedule, instead of $250,000, was $25,000?
Yeah, probably not. I mean, there's a vast difference, but just coming up with $2,500 can be a really extreme sacrifice, I think.
Judge Cousins.
Bail schedules are not the solution. It's because under Humphrey, even the Court of Appeal version of Humphrey, at best, bail schedules are the place to start. And it does provide a mechanism for early release for some people who want to get out before they even make an appearance. But bail schedules are being retooled now. We need to retool them for a wholly different purpose and make them more realistic in terms of what is going on in the community, in the state. I'm a little concerned about the suggestion of a statewide bail schedule. I don't think it should be viewed as a panacea. While it would give standardization, and there's certain benefit to that, there's also huge economic differences between our communities. And what may be appropriate in Marin County would not at all be appropriate, say, in Alpine County. And you still need to have, I think, a fundamental ability of a court to adjust the bail schedule to meet certain obvious things that are going on in the community. That worries me a little. I think there could be room for more standardization. Maybe the approach is a range rather than a fixed amount. I mean, there are various solutions to this that I would hope that we could partner with. And in that respect, in terms of codifying Humphrey, we do know there are things that the Supreme Court sort of threw out there, but didn't elaborate on. There's a skeleton, but the flesh is not there quite yet. And while I would hope that the judicial process would provide some of that information, it's a very slow process, as we all know. And I would hope that there could be some working relationship between the legislative branch and the judicial branch to come up with rules that make sense for everybody. We have participated together in the past in writing rules, and whether they come through a rule of court or a bit of legislation, I would hope that the dialogue could be created to maybe, if we need to, kind of accelerate the information level by having a more aggressive approach to the codification rulemaking authority to bring Humphrey further along than it is.
My understanding is judges can depart from bail schedules currently, correct?
Oh,
Yes.
sure.
Yes,
Sure.
absolutely.
Sure. Except though, my understanding is to issue a lower than schedule, you have to find it's a higher standard than going up on the bail schedule. Does that make any sense to everybody?
No, not quite.
That's not correct?
It's with certain crimes, it's usually the more serious and violent crimes. You cannot depart from a bail schedule without reason, and you have to state that reason on the record, and there has to be a hearing held before you can make that change. There's no burden of proof that's different, but the mechanics of handling it are different, and which creates an interesting problem with Humphrey, because under the statutory scheme, the bail schedules, that's sort of gold. That's where you start. Under Humphrey, you have to make an adjustment, which may or may not be based on some unusual circumstances that would be acknowledged by the statute. So there's sort of a little conflict now between the statutory structure and Humphrey that needs to be massaged in some way.
Mr. Chair, if I
Clarifying Humphrey, just real quick,
Sure.
Judge Cousins, where would you prioritize the legislature look in terms of the various aspects of Humphrey to codify? Is it the ability to pay? Is it the presumption of release on without money bail? I mean, where would you start?
I think probably the biggest thing is the ability to pay. There are already some statutes that touch on ability to pay, like for counsel fees, or there's a statute that I refer to in my memo that sort of is a place to start in some of the ideas. But I think it would help if judges could have a good, clear shopping list of things they can consider, and maybe some things they can't consider as a part of that. I think at some point that needs to happen, whether it's a rule of court or a decision by an appellate court or something from the legislature. We're all acting independently right now, and I think this is an area that calls for some uniformity.
Before leaving, I want to make sure that I also ask all of you the question that I've been asking other panels as well. Is as opposed to relying on the bail bonds industry, some states have partial surety bonds or court-backed bonds where they don't rely on private bail industry at all, merely set a number that if you fail to appear, that you're going to know that that's what you're owed. I guess that's the way that the federal system works, according to Justice Moreno. But do you guys have any thoughts about doing that in California? Do you have any concerns about judges and courts taking that responsibility on?
Well, the law actually already allows for cash deposits to the court. That's 1295 and 1296. So it just needs to be maybe beefed up a little bit if that was something that you were interested in doing, and making it more obvious that it's out there. But people do post cash right now to the courts. It's more limited.
But it has to be the full amount. Is that correct? Right. That's what I'm saying, is that judges would have the authority to say, because right now, right, it's de facto 10% that's owed to the bail bonds here. Like if a court could say, no, you pay us 10%. And you get it all back if you show up.
Mr. Chairman, your question itself identifies what a house of sticks that we have created. Your staff's memo identifies these exorbitant amounts of money. $50,000 is more than half the people in my county earn in a year. But then somebody says, oh, don't worry about that. It's really not 50, it's only 5. And then they take the cut and they extract it from that family, no matter what happens in the case, even if somebody doesn't get accused of the crime. The only narrow, and it's very narrow, appropriate use of money would be if a judge assessed somebody to be an unreasonable flight risk. And please don't confuse that with an FTA, because there's lots of failures to appear that aren't willful or otherwise. But if somebody's adjudicated to be a willful flight risk and a deposit of the deed to the proverbial ranch is necessary, why can't they just place that with the court? And if the goal is to have them not leave, the incentive to get the deed back or that cash equivalent is much more understandable than having them be nicked with that amount up at the front. So
Right.
These huge amounts that we talk about don't have any basis in reality in the first place. And we're down to these other amounts of money in the narrow category of crimes to make sure that we are dealing with an unreasonable flight risk. And I can't think of a single reason why that not only could not, but should not be the exclusive responsibility of the court.
Does anybody have a different opinion on this? Because
No, that's why
I
I
have to imagine
suggested-
that a bill, that judicial council would raise their hand and say, we're not equipped or prepared to be able to do that.
But what Judge Aldridge just said is why I thought from the beginning we should have a statewide bail schedule. It could have ranges that talks about $5,000 instead of $500,000.
There is no question there'll be additional cost to the court. There'll be training. There's the fiduciary responsibility for what money you get. It has to be deposited and accounted for. I mean, there's going to be a lot of legwork to make that happen. And if we're given sufficient support to do it, I would think we could take it on. But the fear will be that it'll be ordered without sufficient financial backing. It's going to have to be eaten out of current staff and staff time, which is, I think, without adjustment would be problematic.
Right.
I think you
I
can,
appreciate that, but it could be zero surety, right? It could just be nothing up front, nothing down. And
Yeah.
the risk is if you don't show up, we're going to come after you for the $25,000 or whatever.
you should look at
Which the courts already
Kentucky.
do for fines and fees.
Kentucky does something very similar where it's a really small amount and the court is the one who collects that. So you need like an administrative cost to that as well. And then if you're going to do something where somebody's going to owe you if they don't show up, how do you collect that? Because again, then we're putting a monetary burden on people that are least likely to be able to afford it, and we're least likely to be able to collect it.
Sure. No, I appreciate that. I mean, I'm not saying it's cost less, but it just seems to take a lot of the financial pressure out of the equation. I do want to be mindful of everybody's time. Does anybody in the committee or staff have any additional questions? All right. Senator Skinner. You're on mute.
It's not so much a question as a comment. I wish that many of my legislative colleagues could have heard from the judges today. The only part I would say that might not influence them in a favorable way, because they share the same fear. I mean, what you're describing, or what some of you described, is that as a judge, that fear of that you would release someone who then goes on to commit the crime, and that then influences the various of the decisions. Certainly, beyond the influence and power of the bail industry, that is also on legislators' minds. So it's one of those needles that all of us have to thread.
I really want to thank everybody. As somebody who practices in front of courts, I am a little bit frustrated when I do hear. I mean, I appreciate the candor about not wanting to end up in the newspaper, right, the next day, and that's what judges really fear. What people should fear is the crimes, right? Not whether or not you should show up in the newspaper. And And we, you know, and we should be administering justice as much as we can, or as you can as judges. And I think that there's an oversensitivity to perhaps appearing in the paper. I think that so much of this can be done and is being done on a daily basis. To do the right thing. And I appreciate y'all being here. And I also appreciate your candor and saying, you know, what is true, that everybody does care about these things as little as perhaps that those should be the influences. Judge Espinosa, I'll give you the last word.
I'm sorry.
I want to say
Oh.
that the decision-making process isn't just influenced by judges' personal concerns for their continued employment, but, you know, judges see themselves not only as the purveyors of justice in their courtrooms, but in some way responsible for community safety in their decision-making process. And I think that that is as big an influence in these decisions about release. It's not just release on bail. Who do we put on probation or release from the county jail as opposed to state prison? These are tough decisions. And it's not just about our personal employment safety. That is a concern. I agree with Judge Aldridge. That is a concern that influences decision-making, but there are other things that influence judges as well. So
and that's what I was trying to say, that should be the legitimate, that should be our, you know, concern is public safety, or that should be judges' concerns.
Yeah, I just want to, I didn't want that comment of mine to be in any way interpreted as a disrespect for that concern, because I think it is also one that, when I've referenced the legislators, similar in that similar vein of, you know, how do you thread this needle to protect public safety, and, you know, not just the fear of the headline. But I wanted to thank you all, as the chair has, for your candor, because I think your expressions of the craziness of the pre-arraignment, because if we go back to this notion of that our real concern should be the public safety, the fact that in this pre-arraignment release that people can get out that could be a real threat to public safety, that's a real issue. And yet then we're holding people that may not be. So, and also, Judge Aldridge, your reference to just, you know, that people can throw around, either the bail industry or legislators, that, well, you know, actually this is not such a high cost, and, you know, the individual will get the money back. When we look at the actual income of most Californians who are in this circumstance, their income is very low. It's very interesting how, you know, as much as California has some very, very wealthy residents, the majority of Californians' incomes are 50,000 and below. So it's, yeah, this, the financial impact's real. And I just thought everything that you all shared would be of great value to my colleagues, but it's a very hard circumstance to set up to allow that kind of interaction.
Well, with that said, I really do appreciate everybody's times and insights here. As you know, we're spending a lot of time on this today. Our staff has worked on this for months. You know, the whole state has been wrestling with this problem for years. It sounds like, despite all that work, we still haven't made as much progress as anybody would like. Although I am heartened to see that it sounds like there is momentum and energy to still try to fix the problem. I do think that because it's so complex, it's a particularly good opportunity for this committee to try to thread the needle and to provide good advice to the legislature. So with that said, thank you all. Thank you all for your time. Thank you for your submissions. I'm sure we'll be reaching back out to you on this and other issues. So it's good to see you. Mindful of the committee's time, I'd like to take, I guess, a lunch break now. We'll reconvene at 2 p.m. for our afternoon's panels. Thank you all very much. Good to see you.
Thank you.